For anyone who's new, welcome to your first TUC webinar and welcome back to anyone else. I'm Anna from the TUC. I'm joined today by Daniel Poet from Thompsons Solicitors. Well, joined again. This is his second appearance. We'll be hearing from him in a few minutes. But first of all, if you'd like to follow along with us with live captions, there's a captions button at the bottom of the screen beneath the video. Click that and you'll be able to do so. We're, of course, recording this as we always do. If you miss anything, don't worry. We will send you a link to a recording. We'll also send you any resources that Daniel uses or he mentions or that we think are helpful for this subject. We've kept a bit of space during today's session for questions to Daniel. Do post those in the Q&A panel at the bottom of the screen and we'll get to as many of those as we can. We are also going to use the chat a little bit today. Daniel has got some questions for you just to see a bit of background information on today's subject. So as I said, Daniel is from Thompsons Solicitors, and Thompsons Solicitors are a great trade union law firm. You may have heard of them before, but do check them out if you haven't. And Thompsons have got lots of lawyers working for them. We are having a joint event with Thompsons Solicitors on the 15th of July in Manchester about the changes that are coming in employment law. So as you may have heard, there is an employment rights bill currently going through Parliament. And that's going to make lots of changes in the workplaces for you, for your members. And we're holding this event so that you can hear more from employment law experts. So we'll put the link in the chat. Do take a look if you haven't registered. If you've already registered or thought about registering and haven't yet completed, you can take a look also. So yeah, we'll be mentioning that again a bit later, but it's a really important event for all reps. So today we're going to be talking about a particular type of workplace illnesses. A few months ago, we had Daniel speak on a webinar about the general things that a workplace rep needs to be aware of when supporting members who have developed a workplace illness, or how to develop policies to stop it happening in the first place. But today, we're going to take a deeper dive into respiratory illnesses. So I'm going to hand over to Daniel just to introduce himself, introduce the subject a bit, and he's going to start off by asking you a couple of questions about this subject, and then we're going to hear a bit more about the rep's role in the process. So Daniel, over to you.
Great, thanks, Anna. I can see there's a really good turnout like a few weeks back when we were doing the workplace illness. That's really good to see, and I can see names and various different unions popping up, so that's great. As Anna said, this is sort of following on, I guess, from the webinar a little while back, just focusing more so on the respiratory disease aspect, which falls under my remit. So just very, very briefly, I'm the national lead for a number of different types of disease, but one of those is what you might recognize as COSH cases, so hazardous substance type cases, of which this would fall under, amongst other things. So that's kind of my background. And although, as Anna says, we're trying to a little bit of a deeper dive, I am conscious about time, so this still remains a bit of a whistle-stop tour. And off the back of this, we're more than happy to follow up with specific sessions on any particular type. What I've done here is to make some general points as far as, well, what are we talking about? What are the causation issues that we have? And then a little bit of a mini focus on particularly silicosis and occupational asthma as two kind of, fairly common areas that we deal with. So a little bit more information on those. So as I said, if we start off, we found it quite useful with the previous seminar, if we just sort of throw it out there a little bit, just to kind of gauge what you guys maybe know or don't know. So I guess you can just sort of answer in the chat and we can have a quick look. But can people name, what would they name if they were asked, well, what are respiratory illnesses in the context of occupational disease type work? Can anyone name some examples, and just so you kind of gauge what people know?
Yeah, put some ideas in the chat. That's great. They're starting to come in and they're speeding by. COPD, asthma, asbestosis. We had Legionnaire's disease a minute ago, emphysema, COVID, mesothelioma, lung cancer.
Yeah. See loads of good answers coming out.
Yeah. This isn't a test, by the way. We will
No,
obviously be speaking about the what the answer is in a minute. We're not gonna like give everyone an exam or something.
no, no. I can see. Do you know what? I was because I've got. If we go to the next slide, just with there's some really good examples. You've actually covered most of them. I'll put in a couple of two or three sort of more unusual ones on the slide. But if we can
Yeah, just
uh
1 second, we'll get the
get
slides
the
loaded
slides
up.
up, brilliant.
Um,
But I think I saw almost all of them covered actually. There might be one or two that weren't covered. So a lot of people saying asthma, which is obviously a very common one, occupational-induced asthma. We've got asbestosis there. We haven't actually separated out mesothelioma. So just briefly, asbestosis obviously caused by asbestos. That's effectively the sort of non-cancerous injury that our lawyers, we have separate asbestos lawyers who do with nothing but asbestos work. The reason being is that they want very low case numbers because very sadly, if you're dealing with a mesothelioma case, you can imagine it's you've got to get straight onto it and almost turn around the case potentially in several months because often those people have very short lifespan once they've been diagnosed. So that's obviously asbestos-related injuries, lung cancer, silicosis. I'm going to talk about a little bit later and talk about the kind of mechanism and what we're talking about there, because that is something which, whether it's on the rise, it's certainly on the rise in terms of the number of cases that are being pursued and I think the general awareness of it. So we can have a look at that. I think I saw someone actually get black lung, which was interesting. The technical name for that is coal workers pneumoconiosis, and it's basically a condition caused by inhaling coal dust, which obviously happened a lot in years gone past. Brown lung is something caused by inhaling cotton fibers, hemp, flax fibers, that sort of thing. Coal workers lung has actually been reproduced there. Respiratory acidosis, that's something where subject to what the individual inhales, you get an overload of CO2, and that's the reaction that the body is having, and that can cause significant complications. Extrinsic allergic alveolitis, that's where you get, there's actually a diagram to the side. And I don't want to get too bogged down in it, but you can see the alveoli there. That's where that can be caused by things like mold spores and bird droppings and these sorts of things, animal proteins, that sort of thing, and is a really, really serious condition as well. COPD, a few people mentioned, and emphysema. RADS is one I didn't think I saw, but it may have been on there. So RADS, as it says, they're reactive airways dysfunction syndrome. That's often a relatively short-lived condition, but it's something that people often develop as a result of a sort of a one-off traumatic burst of something. So they're at work and they're suddenly exposed to a blast of ammonia at high concentration or something like that. So it's not something over a period of time, and it can cause these sorts of irritant respiratory issues. For the most part, it might last 2, 3, 4, 5, 6 months. But it sort of mimics the main symptoms of asthma in that way. So there's as I say, there are, excuse me, any number of other conditions, but there's a kind of a basic flavor of the sorts of things we're talking about. But it's good to know that kind of most of those you seem to have some awareness of. So if we go from the types of conditions, what do people know about the possible causes of these conditions? If we can have another sort of quick response on that. I saw some of them flagged up and mentioned asbestos, but there are obviously a lot of others. I've just talked about a couple, but just any others that anyone's aware of?
Smoking,
Yeah,
airborne
passive
particles,
smoking, passive smoking.
chemicals, workshop fumes, cleaning
Yeah,
chemicals. Uh,
yeah.
yeah, lots of
Someone
causes
mentioned
coming up
lifestyle. Well,
here.
that's an interesting point that comes into the
Yeah,
causation issues that we deal with these cases to some extent. So yeah, asbestos, hazardous substances, animal. Yeah, yeah. Okay. So again, it's really good to know that people seem to have a bit of a sort of a handle on this. So if we go to the next slide, again, this is you can imagine, this list could be, dozens and dozens of pages, but just as a sort of broad examples, irritants like dust or fumes, breathing in coal dust we mentioned before, breathing in spores. So these days, housing disrepair type claims where you have you know, a landlord who's leaving the tenant in some pretty horrific conditions where you've got, for example, black mold in the property, they're not cleaning it off. Those can have very significant effects. Fumes from welding has been a known hazard for a long, long time. Other examples: smelting, pottery making can be incredibly dusty. Plastics manufacturing, I mean, that's incredibly wide, but you know, any number of hazardous substances, you know, have historically been involved in that. Spores from grain and wool, mold from hay, vapors from chemicals, you know, any number of hazardous gases involved in, you know, dozens and dozens, hundreds of production processes. So a couple of examples there: formaldehyde, chlorine, ammonia. We see that all the time. In again, in sort of particularly in sort of car plants production, fumes from paints and solvents is a big thing. And then finally, cleaning materials, lacquers, pesticides. So pesticides, if you're involved in, you know, sort of some sort of industrial gardening or, you know, agriculture, that can be significant. So I think the point to make there is it's, you know, incredibly widespread. And there are any number of, you know, hazards that your members are potentially exposed to, you know, on a daily basis, subject to what they're doing. So it's clearly vital that, you know, as union members, we do our best to cajole these employees into dealing with them as they're supposed to do. So very, very wide ranging, but it looked to me again, yeah, there were loads of good examples there. Just finally, might be a slightly more straightforward one, but just one more question. What sort of industries would you generally associate these respiratory injuries with, sort of in broad terms? Bit of a wider question, but yeah, construction, I see, general manufacturing. Yeah, yeah.
Can I take a guess as well,
Yeah,
Daniel?
absolutely.
Just looking at
Agriculture.
some of these that I hadn't heard of, I'm perhaps taking the easy way out and saying almost any workplace could have some of these in, or is that making
No, no,
it
that's
too
a fair
broad?
summary. I mean, if we this again, there's loads of good examples there. If we go over to the next slide, just again, there's a few examples, but hugely wide ranging, and I think you probably sum it up quite well. You could almost say, look, pretty much any industry. I mean, you know, the likes of myself, where I'm stuck at a desk most of the time, perhaps not so much, but you know, huge swathes of industries and jobs throughout the country, you're going to come into contact with you know, potentially these substances, and so we've got to make sure that you know, the risk is absolutely minimized as far as possible, if not removed. And we'll come on to practical things that the employer should be doing to some extent a little bit later. So, yeah, construction, agriculture, manufacturing, automotive. As I touched on, you'll get load, you know, spray paints, and you get these volatile organic compounds that can cause real respiratory issues. Mining's pretty self-explanatory. Shipbuilding, big historic association with asbestos exposure. Gardeners can be pesticides or chemicals, or you know, and any number of other nasties. So just a few examples there, but I think you're right, Anna. It's kind of broadly pretty much anything. Okay, so if we go to the next slide, again, might be self-explanatory this, but I think the relevant point here is a combination of this slide and the next slide. But common symptoms of all of these conditions, and it's part of the difficulty sometimes in running these cases, and I'll sort of come on to why. But a few examples there: you're going to get breathlessness, you're going to get wheezing, tight chest, persistent chesty coughs, and very frequent chest infections. Now, you know, you could say that pretty much all of those are going to be experienced with pretty much all of the other conditions. So you can see how, to some extent, you know, if you go and see a general physician off the back of a GP referral, some of these conditions are very difficult to diagnose, and that can cause us an issue as lawyers. But those are the symptoms that you're talking about. Now, over the slide is a point I wanted to make as far as, well, why in practical terms, as lawyers, when we're dealing with your member's case, that can be a difficulty, or it's very much a grey area anyway. So I'm sure you're all aware, but the time limit, or limitation as we call it, that applies to personal injury claims is 3 years. So with an accident, that's very straightforward, because you almost always know the accident date, and you know, you will have a definite date in the diary as to when that 3 year runs out, and you have to get your claim issued at court by that point. With respiratory conditions, which are industrial disease cases, it's 3 years from when you knew, or you ought reasonably to have known, that your symptoms may have been caused by a third party. Almost always the employer. Not always. There are sometimes third parties come into play, but for the most part, it's employers. So when if you have a look at the sort of symptoms we're talking about, there is a big question mark in lots of these cases as far as, well, when does this 3-year period run from? Because people will be developing those sorts of symptoms often gradually over a period of time. And yes, there may be some deterioration, but there is often, when people come to us, a big question mark as far as, well, when is our starting point for limitation? When do we have to get this person's claim issued at court? Because sometimes people will say, well, look, I've had these problems for 5, 6, 7, 10 years. And we have to really take a deep dive into their medical records and see, first and foremost, how significant were their symptoms, because there was a caveat in the limitation statute. It basically says, look, if your symptoms are not significant, again, what does that mean? But if they're not significant, so they're really minor, transient, sort of thing. If you're talking about a back injury, it's the odd tweak here and there. You're not taking medication, you're not having any treatment, then the clock doesn't run. But as soon as you start seeing a GP and having some, potentially having some treatment, there's a decent chance it's going to start. But then there become arguments as far as knowledge. So what ought you reasonably to have known? And now, in the context of respiratory conditions, that's often a big contentious area, because we will often be saying, well, okay, they didn't get a diagnosis, they didn't quite know what it was. Maybe some people don't even know what they're being exposed to at work, so they can't reasonably make that link at that time. And so often there is a degree of subjectivity, where we're arguing with the other side. But it's worth bearing in mind, because, as I say, members will almost always start going to their GP with these types of symptoms, relatively low level symptoms, before they know what is going on. And so that's often a battleground. Just briefly over the page, I've got another slide on this later on, so I'll sort of run through this fairly quickly, but this is just to give everyone an idea as far as legally how we look at these cases. So whenever anyone is exposed to a hazardous substance, i.e. it's been classified as a hazardous substance, and so therefore the employer has a degree of knowledge, and that's one of the crucial tests anyway in the context of any of this type of litigation, is, well, what did the employer know, or what ought they to have known, bearing in mind the research that's out there. So a lot of the substances that we've just been talking about have been known to cause injury. The science is settled, and it's for often for decades, and so it's not, the employer cannot say, well, I didn't know anything about this. They are deemed to have knowledge of it, even if they were completely ignorant. Okay, so once they do know that, and this individual is doing some work which is exposing them to one of those substances which can cause an injury, the way that we look at this is that there's a hierarchy of duties. Now, I'll whip through this because there's a slightly better slide later on, and I can give some examples maybe in the context of silicosis, but they've got to assess the risk. Okay, so we're all familiar with the concept of risk assessments, but they've got to do a proper risk assessment. So it's got to be suitable and sufficient under Regulation 3, management regs. First thing first, can you avoid the exposure? You might just be able to do it differently, or you might be able to substitute a less hazardous product. Can you enclose the exposure, so keep people away from it? Can you control it via engineering methods? And we'll talk about a couple of examples later on. So, the employer is obliged to look at this sort of stuff. Are there personal methods? So the obvious example would be something like rotation of work away from the hazardous substance, so you minimize an individual's exposure to it. Maintain controls, and then monitor. That's the kind of last resort. Monitor health surveillance and education. So that's very important as well, because it flags up if people are starting to have difficulties, and then you can get them advice. Over the page, I just wanted to take 2 or 3 slides just to talk about the concept of causation. So it's a concept in personal injury cases that we have to grapple with every single case. So just taking a really quick step back, in order to recover compensation in a personal injury claim, we've got to first and foremost prove that there is a duty owed by somebody. So let's just assume we can tick that box, because almost all of these are going to be in an employer-employee relationship. So therefore, the employer owes a duty of care to the employee, and there's various legislation that obviously feeds into that. Then we've got to prove that there is a breach of that duty of care. Now, in the context of COSH cases and respiratory cases, that is quite often the easier part of a case. we can often show that the employer has not done what they're supposed to do in some relatively clear way. Not always, but in a lot of cases, that is a little bit more straightforward. So if we can do that, that's not enough to recover compensation. So it's not enough just to prove that there was a breach and say, well, there you go, this person, it's reasonable, they should get some compensation. We have to prove by way of independent medical evidence, so not someone who has treated the individual, so an independent expert who's in the correct discipline. Usually in these cases, it will be a physician. Who produces a report with a sworn duty to the court. So they're completely objective, and they will look at all their medical records, and they'll know from us what this person's been exposed to, and they will then form a view as to whether or not there is a link. Okay, so in these types of cases, I mean, all disease cases are difficult on causation, but in these types of cases, it's often even more complicated. And I've just set out there that there's kind of broadly three areas that we deal with. So traumatic injury, what we're talking about there, I won't go over the slide, it's covered in the slide, but traumatic injury, what we're talking about there is, I mentioned it before in the context of RADs, is really somebody who's doing something at work and they are blasted with something for whatever reason, whether it's a defective machine or a colleague mucking about or whatever it is. They're blasted with some sort of chemical, and then they develop an injury off the back of it. Now, the causation test, the legal causation test in those cases would just be the standard but-for test on the bounce probabilities. But for this, would they have developed this condition? Okay. Then we've got what are the majority of cases, which is a cumulative injury. So these are cases where, and a lot of the examples we've just touched upon earlier would fall under this umbrella. These are people who are being exposed to something over and over and over and over, over often, years, if not, decades. And the injury gradually builds up. Okay, so a good example might be something like silicosis in that context. And then finally, we've got exposure, which increases the risk. And there is a particular causation test for mesothelioma and asbestos cases where we have to show that there is a doubling of the risk. So that's it's like its own island, really. But the vast majority of cases, we will be dealing with cumulative injury. So there's a couple of slides just really expanding on this. Over the page, traumatic injury, we've kind of dealt with that. So that's the but-for test. It's often, as I say, there's a one-off leak or explosion, something like that, which is involving a traumatic inhalation injury. Now, those cases in the context of respiratory disease are, as you can imagine, generally a lot more straightforward because, we often know what they've been exposed to. We've then got A&E notes, for example, showing, well, they've just had an incident at work where they were blasted with X and now they've got these symptoms. And it's relatively straightforward because there is a clear link in time between the breach of duty, i.e. the explosion, and them having these acute symptoms immediately off the back of it. And if you look at their medical records, you probably find, well, they didn't have any problems before, or if they did, that maybe some low level problems, but then they've suddenly massively deteriorated off the back of it. So usually that's pretty straightforward because a medical expert is always going to say, look, on balance, there's clearly a link here. So over the page, dealing with cumulative injury. Now, the way that we deal with this, there's a couple. We've got the lung fibrosis example there from silica or cotton. Asthma can develop in this way. So what we're dealing with here is what we call a material contribution test. So all as legally we have to show when there are often a number of potential causes is an expert to say, look, on balance, this made a material contribution towards this condition. And by that, they mean legally what is meant by that is, and it's that case there at the bottom, which I won't elaborate on, Bonington castings is the main case, setting this principle out. But what it's basically saying is, if we can show, and the science is there effectively, to allow an expert to say, look, the exposure to X over the last 10 years has made a material contribution more than de minimis, and that means effectively negligible. So if it's made any sort of appreciable difference, it's not a massively high bar. If they can say, look, this has contributed, it might not be much, but it has contributed. It's not just something we can just push to one side and say, look, the effect is negligible. You then recover for the entire condition, even if there are competing causes. So, it often allows us in very tricky cases to still recover for the full effects of a condition. even though our medical expert will be saying, look, there's potentially other causes here, as long as you can get them to say that. Now, the important thing there is the science has to be there to allow them to say that. And in the context of a lot of these hazardous substances, as long as we can go to an expert and say, well, look, we've proven that they've been exposed to X, whatever it is, then they can often say that. So over the page, one of the issues, just really elaborating on the cumulative injury issue, one of the issues we sometimes have to deal with, because you're dealing with injuries that are built up over a period of time, are how do we balance the effect of negligent and non-negligent exposure? Because there may be certain cases where there are periods of time where there isn't negligent exposure, and then there's period of time where there is. And as lawyers, we have to take very clear statements, just to make it clear what our case is. And sometimes you might have to get an expert in, and maybe often in these cases it would be an occupational hygienist who will look at all the evidence, look at any data there is, and often in these cases there just isn't data, they don't have the air monitoring, and say, well, okay, they were well above for what they call the workplace exposure limits for this 10-year period, but either side of that they were well below and they seem to have the controls in or whatever it is. So we do sometimes have those cases. Now, that can be fine as long as we can go to our expert and go back to the previous point and say, well, look, we've got negligent exposure for this 10-year period out of 20 years. Has that made a material contribution? And if it has, then you're okay. Now, the difficulty becomes when a lot of it is non-negligent and you maybe got a very small part that is negligent. And obviously then that potentially undermines that argument. But it's something to kind of be aware of as a what can be a bit of a fly in the ointment with this type of case. Okay. What I've done next is I've kind of tried to just wouldn't call it necessarily a deep dive, but do a few slides on occupational asthma and then silicosis, just to kind of go into a little bit more detail on those particular areas as obviously something that we see sort of fairly routinely. Occupational asthma, really, really widespread. A few examples of things that are known. So this is settled science. This is not sort of speculative. There are peer-reviewed papers and what have you, linking the exposure of these substances to occupational asthma. So isocyanates, as it says, they're found in paints, varnishes, foams, adhesives, flour dust. Obviously, historically, we used to get a lot of what they used to call baker's lung type cases, and those in the flour mills. Animal protein we talked about before, so animal dander, fur, and other materials. Wood dust, so woodworking type processes, even metals. If you've got a job where you're working with metals, so a couple of examples of platinum, chromium, nickel, latex, and also rosin, which is found in solder flux. So those, again, that's not an exhaustive list, but it gives you an idea as far as how widespread these substances are, and how many processes could potentially lead, if the controls aren't in place, to something like occupational asthma. So in the context of asthma, then, again, we've just talked a little bit about causation and how it's very much the kind of often the key battleground in any personal injury claim, because when you get a medical report and you issue and serve proceedings, if you aren't able to settle, if everyone's familiar with the process, that's what you've got to do. You can try and settle a claim for one of your members, what we call pre-action. So before we issue court proceedings, if they admit, for example, if they admit they've breached their duty, we send them a medical report and we might say, well, this is worth X, they say it's worth Y, and we negotiate a reasonable settlement fairly quickly. If they don't play ball, which won't surprise you is 9 times out of 10, either they don't admit when we think they should, or they make us a rubbish offer or no offer at all. We've then got to issue court proceedings. Now, once you've issued court proceedings, almost always the defendant will ask the court for permission for their own medical expert as a second opinion. So when we say it's their own medical expert, it's exactly the same position as we're in. It's an independent expert who has a duty to the court. It's not somebody who has a duty to report for them, just as our expert doesn't have a duty to report for us. They have to be completely objective. But it won't surprise you to know that the defendants will know experts who tend to be less claimant friendly, and claimants will know experts who tend to be a little bit more claimant friendly. And in a lot of these cases, you will be faced as part of the litigation with an expert who is kind of doing their best to undermine the case. And so their job, to some extent, and now on face value they're objective, but what they'll be doing is looking through the records, and find out, well, how can I undermine this diagnosis first and foremost, and then undermine any material contribution argument. So they'll be looking for constitutional factors. So a few of the issues we grapple with here. So first and foremost, can we identify the specific asthmagen? As it says, most substances can trigger, many substances rather can trigger occupational asthma. So sometimes you just can't pinpoint it. And what you need to bear in mind is the burden of proof is on the claimant with any personal injury claim. So if we can't prove our claim on the balance of probabilities, we lose. The defendant can just sit back. So it's a big evidential hole if we can't kind of point to what we think has caused it. And because what you don't want to be doing is going to an expert and go, look, it could have been this, it could have been that, it could have been that. And it's a very unsatisfactory position to be in, if you're a medical expert, because this medical expert might be cross-examined by a barrister in front of a judge, and they're not going to want to be embarrassed and say, well, okay, I was kind of just taking their word for it. So that can be an issue. Latency period. Again, we could probably have a whole separate talk just purely on latency period. Now, what we mean by that is the amount of time that it takes to develop one of these conditions after somebody has been exposed. So different conditions would have different latency periods broadly, and they can be quite wide, which makes it difficult. So for example, mesothelioma type cases, it's often 3 decades between exposure and developing the condition. Lots of these other conditions can be a lot shorter. They might not be, they might still be 10, 15, 20 years, but they can be only a few years. And so when we're looking at causation, we've always got to bear that in mind, because somebody might come to us and say, well, I've had 3 months of exposure and it's relatively low level, and now I've developed these problems, and there might be an issue there. Equally, someone might have been exposed 35, 40 years ago and not been exposed since, and it might be a condition where the typical latency period, if you're going to get it, is 10 years. And so the defendant expert will jump all over it and say, well, that suggests to me that there is no link here. Individual susceptibility is another point. Now, some of you may be aware of the eggshell skull principle. You probably are. So to some extent, that's not a problem, because what the eggshell skull principle basically says is, look, the claimant is taken as they're found. So if they have a particular vulnerability to a condition and there was a breach of duty, and they go on to develop perhaps an injury that is more severe because of that vulnerability than the average person, then that's fine, because they are taken as they're found, and it just happens that that person is more susceptible and their claim is worth more. That's fine. Where you get into difficulties is if that susceptibility is so acute that an expert is basically left with saying, look, this was probably going to happen anyway because of all these vulnerabilities. They were going to develop this problem anyway. So that can become a bit of a battleground. Multiple sensitizers, so sort of a related point to the first one about identifying the asthmagen. Sometimes you get situations where there are multiple asthmagens potentially from different sources, and so you have that argument as to which one is likely to have made a material contribution. Now, as long as we can prove a material contribution to one of them, you're normally fine, even if there's other ones that have contributed, but that can be an issue as well. Over the page, again, kind of related to some extent, but if somebody's got pre-existing asthma, we see that quite a lot, where they say, well, okay, I've always had asthma since a child, but it was well controlled. I used to have an inhaler that I would toot on once a month, and it barely caused me a problem. And then lo and behold, I've done this job for the last 5 or 10 years, and suddenly I've got this really significant asthma that's causing me a massive problem. So again, that can be fine, as long as the paperwork marries up and everything else sort of tallies to some extent. However, you're almost always going to be faced with a defendant instructed medical expert saying, well, kind of, it often gets worse anyway, and I think a lot of this would have happened anyway, etc., etc. So again, in an ideal world, you want somebody with occupational asthma who has never had a problem, so you can say, well, this wasn't something that could ever have developed in this way, but clearly that's not always the case. I'm slightly conscious of the time, so we can whip through this. Incomplete exposure information. That's another issue, because often people will have done jobs, 2-3 decades that might be causally relevant. They might be the real smoking gun type job, and they just don't know what they've been exposed to, because that employer was a really poor employer, didn't keep records, etc. And maybe that employer's since gone under and the records don't exist. And so in that situation, what you're left with doing is going to an expert and saying, look, this is the process. From what you know of the process, what were they probably exposed to, and in what quantities? But as a lawyer and as a legal team, clearly that's not an enviable position to be in, because to some extent it's speculation. In an ideal world, you just want to be able to pinpoint it, and you want to be able to have a pretty good idea as to the levels that somebody's been exposed to. Again, wrapping up this point as far as common causation issues, anything where there is limited research is going to cause you a problem. So most of the things we've been talking about are well established, links to the various conditions, and everyone is, if you're using that as part of your, production or whatever it is, you're deemed to know about those risks. Now, there are millions of substances that are being used across the board, and there is not always research in place to really back up whether or not they can cause a particular condition. And so if you're in that type of scenario, it's very difficult, because you might be facing an expert saying, look, there's some research in rats that suggests a possible link, but that's about as far as it goes. Maybe, come back to me in 20 years, we'll probably know, but we don't know at the moment. And as I say, it's our burden, it's the claimant's burden to prove. So if you're in that position, you're in a bit of a sticky wicket, because if the science isn't there, it's very difficult to prove your case. And then finally, diagnosis challenges. This is a really important point in the context of respiratory conditions. We touched upon it at the start as far as, well, lots of these conditions, at least at the outset before they become really significant, have basically the same symptoms, or a combination of a number of them. And if they do, the question is, what on earth is the diagnosis? Is it asthma? Is it one of these unusual other conditions? What is it? And so that is often a challenge here, because often people come to you and say, well, look, I've seen a physician, they're kind of not sure, they're doing some lung function tests, and they'll see if they can work it out. And there are a number of diagnostic tools open to them. So as it says there, lung function tests and a very clear history of symptoms, but often people just don't remember. And so, people are not the best historians, and that's no criticism of them, but, they're not always in a position to say, well, it started with this, then it developed into this, which then can be cross-referred to the diagnosis, itself, which will have particular things that the physician is looking for. So all of those are things that we have to grapple with. I mean, ultimately, it's down to the medical expert, but obviously, as lawyers, we've got to decide whether or not an expert is likely to support it before we then say, look, your union should support this and spend some money on it. Okay, I'm just checking the time. So about 20, so I've probably got 5 or 10 minutes. I will whip through this last section on silicosis, if that's okay, and so we've got a bit of time for questions. So the reason I put silicosis in, as I say, it's getting a bit of traction. I mean, at Thompsons, we've got a parliamentary event looking at this, sponsored by an MP in September, just to get a bit more exposure. But some of you may have seen the recent headlines, particularly about engineered stone and these worktops, and it causing silicosis very quickly compared to a lot of other substances that are typically used and are known to be risk factors. So I just want to touch upon what we look for in a silicosis case briefly. So what is silicosis? As it says, long-term lung disease caused by inhaling large amounts of crystalline silica dust. So it's often referred to as respirable crystalline silica, so RCS, you'll see. Often over many years, and we'll talk about the latency very briefly in a minute. It's basically found in pretty much every type of stone, rock, sand, clay at various concentrations. And as it says here, the mechanism, once it's in the lungs, the way it was explained to me by a physician, is it's like tiny, tiny, tiny microscopic ball bearings. And once they get in your lungs, you can't get them out. There's no way of getting them out. And they'll just kind of bounce around and then gradually settle, but they'll cause scarring, and obviously your lungs gradually become less effective over time. So it can be fatal. And what we're seeing is that it's affecting people in their sort of mid-working years, 40s, 50s is really, really common, as opposed to something like mesothelioma, horrific as that is, which tends to affect people of retirement age or later. Silicosis is a bit different, because the latency, as we talked about before, the main thing is the latency period is shorter. Okay, so we'll come on to that in a second. In terms of the industries, pretty obvious, but basically anything where you're cutting or polishing stone masonry, Construction is a big deal. So I've been doing some work. I see there's some Unite members on here, but I've been meeting with Unite and doing some work with the construction section on that. Worktop manufacturing, so cutting the work surfaces, is a really big one. Pottery, ceramics, mining, sandblasting, glass. Now, to give you an idea of the percentage, so sandstone can be 70 to 90% RCS, so really high concentration. Some substances are a bit less, so granite's 20 to 45. Concrete can be anything from 25 upwards to 70. Engineered stone, which is why it's such a big deal, is 97% silica, so almost pure silica. So as soon as you're cutting that stuff, you're off the charts really in terms of your exposure. And our RCS is a grade 1 carcinogen, so it is known to cause cancer in humans. So that once that happens and the science is there, it's signed off. So it's pretty significant. Really briefly, signs and symptoms over the page. Again, we've kind of touched upon them. As you can imagine, it's all the same stuff: shortness of breath, weakness, tiredness. As it says here, it progresses, usually develops after many years of exposure. Typical latency period, if there is such a thing, is 5 to 20 years. Now, there's a slide in a couple of in a couple of slides time which will sort of delve a bit deeper into that, so I won't talk about that in too much detail, but suffice to say, engineered stone, it's a much shorter latency period because the concentration is so high. So that's the relationship. It's the concentration of silica compared to the latency period. Couple of stats here. So over the page is HSE, they've looked at this and they reckon an estimated 600,000 workers are exposed to silica, so it's massive. HSE estimates approximately 600 deaths per year caused by lung cancer associated with silica, and 450 from exposures within the construction sector. So it's a really significant issue. And it says when other diseases are attributable, the number of deaths could be as high as 1,000. And historically, these cases have not been particularly high profile, and partly because I think, people don't know necessarily about the risks, and even the medical experts who are treating these people don't necessarily put two and two together and say, look, like they might with asbestos cases, they normally point you to support groups who will say, look, you might want to take some legal advice. That happens with mesothelioma all the time through, LATSAG and other groups. It doesn't happen with silica. And so people just sort of, they just sort of go their own way and they miss out on compensation they might be due. So there's only 2 or 3 more slides, and then we can sort of wrap it up with some practical stuff. So we touched about the hierarchy of controls before. So examples here of what you might do with silica. So elimination, can you literally remove the hazard? If not, and in most cases you maybe can't, can you substitute it? Well, a good example would be the worktops I've just been talking about. Don't use engineered stone. Okay, these really high concentrations of silica. In Australia, they've just banned it, and there's pressure to ban it in this country. Use something, if you use marble, it's got 10%. It might not be as nice a worktop, but it's probably not killing the, guy or gal who's just been cutting it for the last few months. So that's one option. Engineering controls, the obvious ones are things like dust extraction, and that will be a common one with all of these cases. Will be, have you got, can you have proper extraction, so it's removing the dust before it's being inhaled. Another one with silicosis or any dust claim is water suppression. So what they should really be doing with these presses is having some way of applying water. What that does is it causes the dust to go to the ground because it's weighed down, and it's not inhaled. And so an occupational hygienist will tell you there's almost always a way of using water suppression, and you'll often find people come to us and they've developed silicosis and there's no water suppression been employed at all. And as soon as you know that, you're probably going to be able to establish a breach of duty. So that's the sort of thing we mean by engineering controls. Administrative controls would be rotation, so limit the amount of exposure that people have got to a certain amount of time a day. The final thing, often people think in the context of these cases, well, respirators is probably the first thing you want to do. Go to get a good respirator, you're probably fine. It's actually the last thing you do. Once you've exhausted all the other stuff, you then say, right, you need a respirator. The important thing about a respirator is it's got to be one that properly fits. So if you've got a beard and that sort of thing, you've got to have it face fitted, or else it's just not going to work properly. And it has to be a respirator. It can't just be, a slightly upgraded version of a COVID surgical mask. It's got to be a proper respirator. Over the page, it's worth just just really putting this there as far as how little you need to be exposed to in terms of silica in order to be at risk. So there's a photograph there giving you an idea that little speck there, so a fraction of a 1 penny size, is equivalent to the current workplace exposure limit. Okay, which is not a lot. Okay, and if you're working with something like this, 6, 7, 8 hours a day, and they haven't got the controls in place, you're going to probably be way above that. But it doesn't take much. Now, if you were inhaling that amount of silica for 15 years, then 2.5% of workers would develop silicosis, which is pretty. That to me is quite a shocking statistic in itself. So 2.5 people out of every 100, if they're exposed to that for 15 years, would develop silicosis, which in a lot of cases could be fatal. Now, if you did it for 45 years, it's 30%. So if you spent your entire life, doing one of these jobs, you've got a pretty high chance. Remember that's exposure at the workplace exposure limit. Oftentimes they will be massively above this, and so your percentages are going to go through the roof. We've dealt with the next slide, so we can probably skip that, just about water suppression and dust extraction. And the following one, sorry, Yusuf, I'm letting you rattle through these. The RPE we've just talked about, so it has to be the right type of respirator. The next slide is just an example of the stone worktops and some of the headlines that it's been making. What I want to do at this point, just to wrap it up, with all of that, as I say, it's very much a whistle-stop tour, but I think we posed the same question in the workplace illness seminar a few weeks back. But if we just pause very briefly for a question, in the context of all that sort of background information, what do people think that as reps and as union officials we can be doing in practical terms, ideally before people have developed injuries, but certainly afterwards? Are there any sort of practical things that people think that we should and could be doing?
Yeah, post in the chat, please. Someone's just posted direct to me. H&S walkarounds, masks, raise awareness. These are all good suggestions, getting information out there. Risk assessments. Remember, the risk assessment is the responsibility of the employer, not the safety rep, but of course you can be involved in them. Campaigning for awareness and prevention, all good. Air
Yeah,
filters, yes, because that would be part of the removal.
yeah.
Adequate PPE, absolutely. But remember what Daniel said a few minutes ago, PPE is the one that's the least effective. You do that if you can't do anything else. H&S inspections, etc. Some good
Yeah.
suggestions here.
Really good suggestions. Yeah, I mean, I won't go because I'm conscious of time. The next couple of slides sort of set out a few examples. All of those are really, really sensible. I think my overwhelming message whenever I'm talking about sort of practical tips is make sure it's written down. So if you're making complaints, for example, if you're you and your members are in a very dusty environment, whether it's cutting engineered stone or whatever it is, uh, and you're making complaints and you're raising these issues at health and safety meetings, obviously make sure they're minuted. But equally, if they are going to be informal complaints to some extent, well, I'd much rather that an email has been bashed off to a manager that we can then rely upon, rather than the reality, which I do understand because people are busy and all the rest of it. But a quick conversation that is then denied, later on. If you can turn up and say, well, here's 6 emails over the last 18 months where I've been raising this issue and they didn't do anything about it. If we're armed as lawyers with that information, it's very hard for the defendant to then say, well, we knew nothing about this. No one's been raising it with us. So always keep paperwork. Keep things like, if there was a hazard data sheet where you're concerned about something, maybe keep that so exactly what the chemical is in a particular substance you're working with, because sometimes processes change, and if we're pursuing a claim a few years later, they might say, well, we don't use that anymore, we haven't got the records or whatever it is. So keep contemporaneous documentation. The one final point I would make is, if this talk is about respiratory diseases, and often it's about dusty type conditions, not always as we talked about, but if it's something where there is a tangible physical presentation of the problem, so a really dusty environment, try and get photos, because I mean, I can think of a silicosis case we had fairly recently where the defendant said, look at our paperwork, we've jumped through all these hoops to reduce the risk. We don't accept what you're saying, that this was a very dusty environment, we've got this amazing extraction unit, etc., etc. And then luckily the member had taken a lot of photos, and as soon as we served the photos that showed a carpet of dust everywhere, they just admitted. And had he not had those photos, it'd have been very difficult, because we would have been turning up at court saying, look, honest judge, believe us. And they would be turning up saying, no, 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 we got all these fantastic controls in place. So photos are fantastic. I can think of another case where it was exposure to chemicals, and just again, they were mixing chemicals. It was incredibly dusty, these really hazardous substances, and they said, no, no, there's never any mess, blah blah blah. And again, we had loads of photos where we had photos of literally people mucking about, throwing this stuff at each other, video, all this sort of stuff, and they had to fold. So anything like that, just get it recorded, is what I would say. So that's probably me done, but I'm happy to deal with any other questions if there's time.
Thanks, Daniel. We've got a few minutes left, and I just want to highlight a couple of the things there that you said about, obviously the hierarchy of things that an employer needs to be doing in these situations. I think that's really important. And of course, we will email out these resources to you probably tomorrow morning. Do take a look at that slide, and note the order that an employer should be doing things in. I want to ask you a question about the very last thing you just said about evidence. Firstly, I think your point about keep raising these things with management, even if you don't get a response, because I think this is important for any type of union rep activity, be it health and safety, be it industrial illness, or be it something else in the workplace. You've got to raise it with management, and if you've got evidence that you've kept raising things and nothing gets done, of course we hope it doesn't get that far, but you've got evidence that they didn't act when they were knowledgeable
Hmm.
about something. So, Daniel, you mentioned taking photographs in the workplace, and a viewer has asked, could that be a conduct issue? Are you allowed to take pictures? Could the employer ever discipline you for doing that?
What it kind of, to some extent, I think it probably depends on what they're doing at work and whether or not, often in these scenarios, the employer might try and spuriously say, well, it's, I don't know, not trade secrets, but that sort of thing is involved I mean, in an ideal world, I would tell them that's what you're going to do and lay it out and say, look, we need to take some photographs and video. And it's, and if they refuse you, then if it's recorded, then if it comes to us later on, we can say, look, we can say to a judge, look, the reason we haven't got this evidence is because they refused. You can make an inference as to why they refused, and that's weight to our evidence, where we say, look, this thing was covered in dust or whatever it was. Why do you think they refused? Because the reason they're giving you is completely spurious. What I don't want to do is start saying to people, yeah, go off and take photos and video wherever you want. Don't worry about it. Best thing is just, my experience is just to be upfront about it, and say this is what we intend to do, and ideally get them to give you the go ahead.
Sure. Thank you. Quite early on in the webinar, you mentioned the difference between negligible and non-negligible exposure. Can you give us an example of what a non-negligible exposure might be? So I would assume that if it's negligible, it implies that the employer has been lax about something. They've let something happen. What
Yeah.
does non-negligible exposure
Non-negligible.
mean?
Well, yeah. What it broadly means, I mean, in the context of respiratory type illnesses, it's probably less common than in other industrial disease areas. So the easiest way to explain it might be something like, in the context of a hand-arm vibration claim. So that hand-arm vibration is something that builds up over a period of time. It's what they call a divisible injury, and so all exposure to vibration technically is contributing towards the injury. So you might have someone who's done a job for 20 years, and it might be that for 10 years of that, they've been digging up the roads all day, every day, and the levels of vibration are well above where they should be. So it's probably negligent. So you've got negligent exposure. Then they get promoted and they're a manager, and they're not really on the tools. And if they are, they're on the tools 5 minutes here, 10 minutes there. And their exposure is probably below what is known to be the levels at which there is a risk. Because obviously, if you're only using, you know, 5 minutes here and there, there is no foreseeable risk. Your exposure is too low. So you might have a period of 10 years where they've got tons, and then another 5 years where they've got hardly any, and then they might go back on the tools for 5 years and then develop the symptoms. Well, the period in between where they're managing is probably a non-negligent period, but they've got the exposure before and after, which is probably negligent, if that makes sense. So that's kind of broadly what we're talking about.
Thanks, Daniel. We've got a viewer who says he's a bin man, and a lot of households don't bag their dust or ash correctly.
Right.
So it's unavoidable for them to breathe it in when retrieving bins. What things could their employer do to eliminate or reduce that risk?
Well, I guess the first obvious thing is some communication to the households, whether they ignore it or not, but some attempt to say, listen, please don't put ash in your, whatever it is in your bins. And then I guess um, if that's not adhered to, I don't know whether it's often the same people doing this sort of thing, but if you say, well, look, we will suspend your, I don't know if they're going to be able to do that in practical terms, but you get 3 strikes if you keep doing it. That sort of thing.
Hmm.
Or you put a sticker on there. I know some bin collections, they'll put a sticker on if you've put something, not that I've ever done it,
Hmm.
you
Hmm.
appreciate, but they'll put a sticker on, won't they, saying,
Hmm.
you put the wrong thing in or whatever. That type of thing. And then in terms of whether they give you any basic respiratory protection. I mean, you're not going to be able to show that it justified, respirators being dished out to all of the, the bin people, but a basic mask in certain situations, maybe, you could make an argument if it was common enough. But again, it comes back to recording it. So you've got to record that this is happening, or else the employer's just going to say, well, look, this is once in a blue moon. The risk is not there because if you're exposed
Sure.
to ash from a barbecue, once every 6 weeks for a very modest period of time, that it's not foreseeable that you would develop an injury in that situation. It's got to be fairly regular.
So
Um,
it's about recording the frequency
yeah.
and the amount. So that leads me into I think what will be our final question. We've had a viewer who said, "My employer does not monitor the environment that I work in, and there is dust extraction involved. What can this member or this rep do if the employer doesn't monitor it?"
So, I mean, they have an obligation to monitor, but almost always we'll get cases where the employer just hasn't got any air monitoring, and they will try and rely upon that and say, well, you can't prove, as we talked about, it's our burden. You can't prove that the levels were above this high. Now, there is case law which helps claimants in that situation because if you're in the unfortunate position, this person where they had a case, what the case law basically says is, look, if the employer is not complying with their legal duties, in this case, air monitoring, then the claimant's witness evidence gets a huge amount of weight because they can't benefit from the fact that they haven't complied with their legal duties by saying, well, you can't prove this because well, the reason we can't prove it is because you didn't do any air monitoring. So in those cases, as I say, the claimant's given a huge amount of weight. Now, so there is protection there in this scenario, but what you ideally want is just some air monitoring. So I think it's one of those things where you just need to batter away at them in health and safety meetings and keep going on about it until they just relent and do it. Now, that's easy said. It's easy for me to sit here and say that, but that's the reality of it. Is just to keep going on about it. Say, look, we think there's a risk here because it's a really dusty environment. Maybe sort of say, look, you could be facing a load of claims here. Play that card unless you have a look at this and just really push for it that way.
But I think that's really great advice, Daniel, because any workplace issue, the first step is to bring it up.
Yeah.
And that might not solve it straight away. I imagine it in lots of situations, most situations it doesn't. But you've got to bring it up in order to get something addressed. So bring
Hmm.
it up at your rep meetings, your health and safety committee meetings, and then you take it from there. Maybe Daniel's suggestion of this is getting more and more serious, more and people will be affected by it. And of course, record how often you are noticing this, be it dust, be it the collecting bins, whatever it is. This can be applied to so many different situations, not just specific case we talked
Yeah.
about. The
Yeah.
processes are going to be the same in your workplace, in your role as a health and safety rep. So it's three
Exactly.
o'clock, and we've learned loads over the past hour about respiratory illnesses specifically, and also the processes in general that a safety rep needs to follow or should follow to help prevent these in the first place. Because I know you all deal with a lot of casework, but our aim here is prevention before we even get to
Yeah.
a member um, having an injury. So we're going to finish things for now. We will be organising another webinar in a couple of months' time that is going to look specifically at mesothelioma and asbestos-related industrial diseases. But thank you for joining us today. Thank you to Daniel and thank you to Thompsons. As always, you are great partners to work with. We will see you all soon for another webinar, and enjoy the warm weather that's coming up for us all. Bye for now.